We're going to talk this morning about the case of Marbury versus Madison. Now, this is a case that everyone's heard of in this country, presumably. Most of the people who have heard of it realize it's famous for having introduced into American law or adopted into Supreme Court case law the principle of judicial review, which is the legal principle that says that the judicial branch has the power to interpret the Constitution, apply its interpretation of the Constitution against acts of the legislature, and if it finds those acts of the legislature to be inconsistent with the requirements of the Constitution, invalidate them. The judicial review power is routinely exercised today. We all get excited when major cases come up challenging the constitutionality of congressional legislation. Most recently, the Affordable Health Care Act, the Obamacare Act. Everyone gets excited. But what's interesting is that we all assume the reality of the judicial review power. No one questions that so much anymore. And I want to take us back to a time in our history when the judicial review power itself was somewhat questionable, let alone its application in a particular instance. And so I'm going to educate you on statutes that some of you will know and some of you will never have wanted to know anything about. But that's what happens when you're a captive audience. So we're going to go back actually to the Constitutional Convention briefly. We're going to talk about the drafting of the third article of the Constitution, which provided for the judicial branch of government. And if you look at that, what you realize is that the framers of the Constitution had a hard time with the judicial branch. You pull this out of the language that they eventually chose to use. There is a description of the judicial power of the United States. It includes what are called federal questions. The courts of the new federal government will be able to decide cases involving federal questions. And it also includes something called diversity jurisdiction, which is suits between citizens of different states. The framers thought that state courts couldn't be trusted with those, that they would be disposed to favor the claim of their own citizen against the claim of the out-of-stater, or there would at least be that perceived bias. So those sorts of cases were also to be entrusted to the federal courts. Okay, well, that's good. Now, what will the federal courts look like? And that's where the discussions collapsed. Everyone agreed there should be one Supreme Court of the United States, and that it should exercise two types of jurisdiction, original and appellate, but they couldn't decide what anything else should look like. What the lower federal courts should look like. Should there be trial courts, presumably? Should there be intermediate appellate courts? Maybe. Not really sure. And eventually what the framers decided to do, being human and very hot, was to say, look, why don't we let the first Congress figure that out? So they dropped a line in that says there shall be one Supreme Court and such inferior courts as the Congress may from time to time determine. They punted, which was fine. They do that elsewhere in the Constitution, too. But they did fix the appellate and original jurisdiction categories. I'll say a word about that because it's going to become important when we get to the Marbury case. Original jurisdiction, that means cases in which the Supreme Court sits as a trial court. So there's witnesses and objection, Your Honor, and all that stuff. The parties can come. Those were to be cases, for the most part, involving foreign countries and states. So if the state's a party or if the case involves an ambassador or something like that, then the Supreme Court can sit as a trial court. And you may know it still does occasionally. If Oklahoma and Arkansas sue each other, the Supreme Court hears the case as a trial court. Now, the appellate jurisdiction was, again, sort of punting, everything else. Okay, so that's easy. So they write everything else shall be appellate jurisdiction, meaning that the claim has to first be heard by a lower court, and then the Supreme Court can resolve the issues that the lower court doesn't sort out to the satisfaction of both of the parties to see if the lower court made any sort of a mistake. Now, Constitution's ratified, new president, new Congress, and one of the first things the first Congress did was to tackle that problem of these lower federal courts. And they put together something called the Judiciary Act of 1789. First Congress elected in 88. They take their seats in 1789, and here we go, sleeves rolled up, the Judiciary Act. And they created a somewhat flawed system that worked in material part like this. There should be trial courts. So we're going to have trial courts, and we're going to let the president appoint judges, Senate will confirm them for what we'll call district courts. And there'll be a district of New Jersey with a judge, maybe an eastern district of Virginia and a western district of Virginia, because Virginia's kind of big. There'll be a district of Maryland. And so all that's taken care of. Now, should there be intermediate appeal courts? Yeah, everybody thought. But what should they look like? Now, nowadays, you know that we call them the circuit courts, and they got circuit judges, and you know, there's this whole separate layer. But back in 1789, Congress thought, why don't we do it like this? Why don't we let the circuit court consist of the district judge whose decision's being appealed, and seated next to him will be one of the Supreme Court justices. So we'll send them riding around the country on circuit. And so the district of, let's say you have a case in the Eastern District of Virginia and you think the judge is an idiot and you lose. You say, I'm going to appeal this. The judge says, okay. And they wait until the time comes. Hey, look, there's the Supreme Court justice. My favorite Justice Bushrod Washington, for instance, of whom you've now heard. You may not have. It was George's nephew and heir. Here he comes, and he rides in. And so the district judge takes his district judge hat. They didn't wear hats, but assuming that he did, takes his district judge hat off, puts on a circuit judge hat. It's the same guy, but now Bushrod Washington sitting next to him. Okay, so what's your complaint? Now, you can imagine as a party, this isn't the optimal situation. If you're the party complaining, he was wrong. You got to persuade the justice that he was wrong. And if they disagree, then you can file something called a writ of error, and the justice will take the file, carry it back to Washington with him, and then he and his colleagues on the court will hear it. Now, there are certain advantages to this. One justice will already have heard the case, but one justice will already have ruled on the case also. So he's going to come in kind of, you know, with an edge. I've never done a study to see how many of these were successful, but it would be an interesting how many times the justice who carried the file up was reversed by his colleagues. That'd be interesting to see. But the worst part of the system wasn't that. It was that the justices hated it. And you can imagine why. Let's say you're the new person on the court, and the Chief Justice assigns the districts. And John Marshall, when he becomes Chief Justice, he always gets the Fourth Circuit, which is Richmond, right? So he just goes and says bye, and he goes home. And he hangs out and he does cases and goes to Raleigh, North Carolina, which was pleasant, and plays Boole in the street with the members of the bar, and we know a lot about it. Meanwhile, the new guy gets, wait for it, Georgia, which is malaria-infested swamps, and they complained constantly about how awful this was, this circuit riding responsibility, those who got the really bad circuits to ride in. Well, that's the setup until 1801. George Washington serves 2 terms, John Adams elected. President, he's a one-term president. Things don't go so well for John Adams. But as he's leaving, he's not just leaving by himself. Some of you know that we had after Washington's term, 2 political parties developed. The Federalists, which was sort of New England-based. Adams was the nominal head. Alexander Hamilton was the brains. And what we called the Democratic Republicans, which was Thomas Jefferson's gang. And Jefferson's party hated the Federalists. The Federalists hated Jefferson. Some of them thought he was the Antichrist. They broke out over issues of, you know, wine, no wine, France versus England, agriculture versus industrial development, and this sort of thing. But so when Jefferson wins in 1800, Adams is a one-term president. Adams is in a bit of a panic. As is his party. They're not only going to lose the White House, they're going to lose the House of Representatives, and a couple of years later, the Federalist Party is going to lose the Senate. and they'll no longer be really a viable force in American politics. So what's a good Federalist to do? Well, what Adams did was to take two things and combine them. One was this perennial Supreme Court antipathy towards the circuit riding system. And the other was this panic that the Jeffersonian Republicans / Antichrists were going to destroy the Republic. And he got his Congress, the Federalist Congress, just as they're about to leave office. Jefferson's won, but there's a long time lag before Jefferson will be sworn in, to pass a new Judiciary Act, the Judiciary Act of 1801. And the Judiciary Act of 1801 says, the circuit riding thing didn't work, so we're going to create a whole bunch of new independent circuit courts, and they'll be staffed by circuit court judges, and we're going to create a bunch of sort of lower order judges, justices of the peace, to handle a lot of smaller matters, and primarily not just in urban areas, but including in urban areas. There are going to be 42 of those. There are going to be a whole lot of new circuit judges, and I'm going to save Jefferson the trouble, I'm going to appoint them now. And so he sat down and started naming. The Federalist Congress was running these things through like mad. Jefferson was furious about this. His line in correspondence was, the Federalists have retreated into the judiciary as a stronghold, and from there they intend to batter down all the works of republicanism, which is kind of what Marbury will be about, as you'll see. So for the Jeffersonians. So all these people are appointed. Now, the process of appointment is kind of interesting. They get nominated, they get confirmed by the Senate, and then they get these certificates saying, you're a justice of the peace or you're a circuit court judge. And they're all supposed to be signed by the Secretary of State and then delivered to the recipient, who can then go into action, right, for these 5-year terms for justice of the peace and life terms for the circuit court judges. Well, who's the Secretary of State at this time? Interestingly, it's a fellow named John Marshall, who was probably the leading Federalist in Virginia. This isn't all Marshall was doing. The Supreme Court Chief Justice had resigned. Adams had to fill that spot. The first few people that he invited to become Chief Justice turned him down because they had better jobs. John Jay, for instance, was happier being governor of New York because there was more going on than on the Supreme Court. So eventually Adams said to Marshall, who was helping him vet these candidates, it's a bit like Bush Cheney, well, I guess I'll have to pick you, right? And Marshall said, cool, or the late 18th century equivalent. And so he got conferred. So he was actually simultaneously Chief Justice of the United States and Secretary of State. That's the only time that's ever happened, or probably ever will happen. Well, Marshall, all this stuff gets approved the last day the Adams administration's in office. Marshall, they all get signed, but he doesn't have time, evidently, to deliver them. So what happens to these things is that they're left in his office when he leaves. Jefferson gets sworn in the next day, a bunch of these certificates. And Jefferson's Secretary of State is James Madison, his friend. Madison goes into his office, and as you do, I'm romanticizing a little bit, you look in the drawers, see what the guy left, the last guy, and there's all this big stack of certificates. And so he says to Jefferson, what do we do with these? And he looks, and they're all famous, sort of known Federalist Party members. And Jefferson says, essentially, trash them. They weren't legally operative until they were delivered. So they weren't delivered, so they're void. So we can ignore them. And then he gets his Congress to set about repealing the 1801 Judiciary Act. And they'll do that by passing an 1802 Judiciary Act that goes back to the old 1789 Act and, for good measure, changes the dates of meeting of the Supreme Court to eliminate what had been the June term in favor of just a February term, which essentially says the Supreme Court's not going to meet at all during the year 1802, which he figures will give people breathe so they won't have an opportunity to get together and decide that what he's just done is unconstitutional, if they choose to create or recognize a judicial review power. Time passes, and we don't know what went on behind the scenes. This case is so complex, and there's so many unanswered questions. But we do know that in 1803, William Marbury shows up. Marbury was one of the justices of the peace who didn't get a certificate, along with 3 other guys who get forgotten. Actually 4 plaintiffs in Marbury versus Madison. And they've got to figure out, they're going to file a lawsuit to get their certificate. So where do they do it? Where do they do it? And the answer they come up with is, let's file this in the Supreme Court. Now, can they do that? Well, remember, I told you that Article 3 says that the Supreme Court does have original jurisdiction in some cases, but it's cases involving ambassadors or, countries and states and stuff. And this isn't that. But Marbury says, aha, yeah, but look, the 1789 Judiciary Act says that, this is the statute creating the lower federal courts, that the federal courts can have the jurisdiction to issue what are called writs of mandamus, which is we command you to, which is orders, to public officials. And that's what I want. I want to file suit and get the Supreme Court to issue a writ of mandamus ordering James Madison, the Secretary of State, to give me my stupid certificate so I can start drawing a federal salary as a justice of the peace. And the same with the other 3 guys. So that's the lawsuit. Now, it gets to the Supreme Court immediately, and the court gets it and considers it and eventually issues one of the most creative and ingenious opinions ever in the history of the Supreme Court. Structurally, because here's what the court says in the Marbury versus Madison opinion. Some of you know this. There are really 3 issues involved. Do we have jurisdiction, right, over this case? That's the first question in any lawsuit. Assuming we do have jurisdiction, is this relief, the requested relief, available to this party? So can Marbury get a writ of mandamus here? And third, if so, should he get it here? Is a writ of mandamus warranted? Are we going to issue an order to James Madison to give up this certificate? And the court decides to answer questions 2 and 3 first. And that's what's unusual about this. And get to the jurisdictional question later. So first is, yes, mandamus is warranted. Judiciary Act of 1783, Section 13 says we can issue writs of mandamus to public officials, so we could issue this relief. Question 2, should we? Yeah. Marshall, and now understand the irony here, Madison should have given up those certificates in sort of unwritten that I signed and didn't have time to deliver. You may be saying, is there a conflict of interest here? Yeah, but this is the early 19th century, and there are different rules in play. That may be the subject of a later talk. So we've slammed the Jeffersonians, right? Madison did wrong. We should order you to give up your certificate. We're seeing great constitutional crisis looming, right? Because what's Madison going to do when John Marshall orders him to give up this? Are the Jeffersonians going to cave to the Federalists on the court? Right, this is where the chapter would end if this were a thriller. Okay, but we're going to go ahead quick to next chapter. And the answer is that question doesn't have to be answered because in Part 3, Marshall for the court says, yeah, but we don't really have jurisdiction. We don't? Why don't we have jurisdiction? Well, this Section 13 of the Judiciary Act does say that we can issue writs of mandamus to public officials, but it's unconstitutional because Article 3 says we have original jurisdiction in only these few instances, and Congress doesn't have the power through legislating to amend the Constitution by adding additional original jurisdiction to the court. If Congress wants to give us additional cases in which we can sit as a trial court, Congress has to go through the amendment process provided for in the Constitution. So, wow. And can we do this, the court? Absolutely. And this is the most famous line from Marbury versus Madison. It is emphatically the province and duty, the court says, of the judicial department to say what the law is. And the law includes the Constitution. That's the claiming of the power of judicial review. Now, it's a brilliant decision because it slams the political opponents of the Federalists and claims the judicial review power. It may well be that the intent was then to embark upon a series of invalidation decisions as the Jeffersonians put out legislation with which the Federalist Court disagreed. We don't know, and we can't know the answer to that question because Jefferson reacted. What Jefferson did was, and this is maybe a post hoc ergo propter hoc because this is after, so therefore because of argument. We don't have a lot of evidence on this because, again, these are backroom conversations, but we do know the sequence of events. That about a year later, before the court really could ramp up on the exercise of its judicial review power, Jefferson instigated the impeachment of a Supreme Court justice, Marshall's colleague Samuel Chase. And the Chase impeachment was chilling to the court. Samuel Chase would take more time to describe than we have, but he was found not guilty. He was a bit of a provocateur. He made political speeches in grand jury charges, et cetera. He's let off, but evidently the court was upset. There's some evidence that Marshall was actually, who was in the room, was seen to cry. The perversity of the Chase impeachment, incidentally, was it was presided over by the President of the Senate, the Vice President of the United States, Aaron Burr, a name you'll remember, who at the time was indicted for murder in New Jersey for killing Alexander Hamilton, the only time in history some wag noted that an indicted murderer had presided over the trial of a Supreme Court justice. So a little bit of perversity. But it is true that after the Chase impeachment, after Marbury, John Marshall never exercised the judicial review power again to invalidate an act of the federal Congress. He went after a number of state statutes, but he never again said to Congress, you can't do that, it's unconstitutional. Indeed, the court itself as an institution didn't exercise the judicial review power for 50 years. And the next time we see it again against the federal government is in the Dred Scott decision, when Roger Taney uses the judicial review power to invalidate the Missouri Compromise. That's a topic for another day. The last thing I want to say is, and some of you know this, Marbury and Madison, Marbury doesn't get his commission, but his portrait hangs in the court today, as does Madison's. They're side by side in a little dining room off the main dining room in the Supreme Court building in Washington, where they serve as a reminder to the court and to us, I suppose, of this powerful doctrine of judicial review that our court claimed in the Marbury versus Madison decision. I'd like to suggest that it might be useful if they also served as a reminder to the court and maybe the rest of us of the difficulties of working out the operational mechanics of our Constitution, the strong likelihood of interbranch struggle, and the difficulties as a people, we the people, of sustaining the form of self-governance that our framers put together. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.